Welcome, everyone, and thank you for attending today's webinar, Lessons for Avoiding Medicaid Fraud, Waste, and Abuse, a presentation for New Jersey Allergy and Immunology providers. I'm Melanie Donnelly, and I'm an administrative analyst here in the New Jersey Office of the State Comptroller's Medicaid Fraud Division. And today's training is specifically tailored for allergy and immunology providers who provide services to New Jersey Medicaid members. Today's presentation will be recorded, and following this, the slides you're about to see will be shared by email as well as posted on the Office of the State Comptroller's website. And we're presenting today in partnership with a number of New Jersey state agencies and key stakeholders of the New Jersey FamilyCare program, including the Office of the State Comptroller Medicaid Fraud Division, which, as I mentioned, that's the agency that I'm a part of, the Department of Human Services Division of Medical Assistance and Health Services, the New Jersey FamilyCare Managed Care Organizations, and the Office of the Insurance Fraud Prosecutor Medicaid Fraud Control Unit. And before we begin, we just want to thank those of you who are enrolled as New Jersey FamilyCare providers and who provide services to members, Medicaid members here in the state of New Jersey. The work that you do is very important, and thank you for being a part of it. So just a bit of housekeeping. This presentation is intended for general educational purposes only. It doesn't replace your responsibility to seek professional guidance and observe the laws and regulations that pertain to your practice as a Medicaid provider, as well as exercise professional judgment. So we have some goals for today, which are to help you better understand the Medicaid program's regulatory oversight and structure, as well as compliance requirements here in New Jersey, the Medicaid documentation requirements for payment, fraud, waste, and abuse obligations of providers, as well as red flag areas and consequences for non-compliance. If you do have questions today, we ask that you enter them into the Q&A portion of Zoom. This allows us to be able to take the questions back at the end of the presentation and respond to them in writing at a later date. So again, please utilize the Q&A for questions, not the chat. So now that the housekeeping items are out of the way, we're going to get started. And I just want to go over briefly what Medicaid is. So Medicaid is a jointly funded federal and state program that provides funding for medical costs and specialized services for those eligible individuals. And it's voluntary to participate in this. If you do want to participate, you must know, accept, and abide by the rules and regulations. And if you want to continue participation, it does require compliance with the regulatory requirements. And throughout this presentation, you might hear Medicaid or New Jersey FamilyCare used interchangeably, and that is because New Jersey FamilyCare is the name of the Medicaid program. Here in New Jersey, it includes Medicaid, the Children's Health Insurance Program, which is CHIP, Medicaid expansion, as well as the services provided through the 5 managed care organizations. So it's all encompassing. And now I'm going to turn it over to Geraldine Molinari, who's the Director of Managed Provider Relations at the Division of Medical Assistance and Health Services. She's going to talk a bit about Medicaid oversight in New Jersey.
Thank you, Melanie. Good morning. So the next slide will show the structure for Medicaid oversight. And here we introduce 2 streams of oversight. On the left side, we start with the Department of Law and Public Safety, and in the bottom box on that side, you'll see the Medicaid Fraud Control Unit, which is under the Division of Criminal Justice and the Office of the Insurance Fraud Prosecutor. And if we move over to the right side, you'll see that the primary oversight for Medicaid starts with the Centers for Medicare and Medicaid Services, the federal entity. And both the Department of Human Services, which is the division that the department that I work in the Division of Medical Assistance and Health Services, and the Office of the State Comptroller and the Medicaid Fraud Division report to CMS. The Department of Human Services then has direct contracts with the Medicaid managed care organizations. And the next slide, this gives a little bit more detail about the expectations and responsibilities of each of these entities. And the CMS establishes general Medicaid requirements, and they oversee the New Jersey Medicaid program. They also approve provider networks and capacities for the individual counties in New Jersey and the state. And as you would imagine right now, with a lot of changes with HR 1, the CMS is who we're looking to for guidance about what the federal expectations are. And as a result of that direction, the Department of Human Services and New Jersey FamilyCare, we manage and administer the New Jersey FamilyCare programs. So New Jersey FamilyCare is the brand that we use for Medicaid. So, you know, if you see member materials from an individual health plan, they will typically specify New Jersey FamilyCare/Medicaid, or they may just call it New Jersey FamilyCare. And the Department of Human Services contracts with the MCOs to provide the services to members. We also oversee the MCO compliance with the state Medicaid contract. In addition, the Office of the State Comptroller or Medicaid Fraud Division, they also have a significant piece in the oversight of the contract for, and you'll see that as you hear the people from the SIU speak during this presentation. So after the oversight of the state, we then go to the managed care organizations, and the managed care organizations offer benefit packages and to support the members. They provide a network of providers to service the members. They coordinate care among the based on the members' needs, and they're responsible to comply with the MCO contracts and the program requirements. Next slide, please. Here we have the 5 entities that have a direct contract with Medicaid to administer New Jersey FamilyCare. So these are the Medicaid managed care organizations. We have Aetna, Better Health, Fidelis, Horizon, United, and WellPoint. And each of those entities actually has they have a standard New Jersey FamilyCare program, and they also all have a brand that is a combination of Medicare, Medicaid, which we call our FIDE SNP. And those are for members that are eligible for Medicare and Medicaid, and they have a little bit different names, but they're all under the umbrella of these 5 managed care organizations. Next slide. So this will just give you now we start to introduce the responsibility of you as providers. And there's a federal requirement. It's now starting to seem like it's a little old because it's from 2018, but it's a big change for providers. And based on the 21st Century Cures Act, that federal law required that all healthcare providers have to enroll with the state-specific Medicaid program if they participate in an MCO network. So anytime you are interested in working with any of the 5 health plans, prior to doing that, you have to enroll with New Jersey Medicaid. So that is the impact for you as a provider, if we're looking at the 4th bullet down, is that all the providers have to go enroll with Medicaid through the Gainwell Technologies, which is our is the entity that manages our enrollment, provider enrollment. So this is in the contract that the health plans have with us. So if you happen to start to work with the health plan and you're not a 21st Century Cures provider, at some point we will advise them that we're seeing claims, and that they will have to make sure that you as a provider are enrolled with New Jersey Medicaid. And providers enrolling to do the 21st Century Cures Act, and you don't say that you're going to accept members that are fee for service. You're just enrolling as an entity so that we vetted all providers that are servicing members in the managed care organizations. Next slide. And here's the njmms.com site, which as a provider, if you're servicing Medicaid members, you should save because it has a lot of detailed information. Here you'll see the full managed care contract with the first arrow is it posted there. It's an 800-page document, but the provisions that directly impact providers and especially for 21st century cures are in Article 4.8.1A3. And also here, if you as a provider need to fill out an application, you may be registered as an individual provider and then you form a group. You would then be submitting a 21st Century Cures application for the group, and all of the provider enrollment applications are found on the NJMMS website, and you see the arrow to where they're found on the left side. The questions specific to provider enrollment should be addressed as well to the phone number there and also the email address at njmms providerenrollment@gainwelltechnologies.com. Next slide. And another really critical resource as you're servicing members and as you're trying to understand new programs is the newsletters and alerts. And we use Medicaid newsletters to introduce new programs or services, especially when there's updates to regulations or we're introducing a new program. So this site has all the newsletters, and when you register, you get alerts to get the newsletters, but at any point in time, you can go to this site to newsletters and alerts and search, and you can pull up the newsletters, all the ones from last year. You can put in a keyword. So it's really a valuable resource to make sure you're following the guidelines that you're expected to follow. And we outline those in newsletters as the best way to communicate with providers when there's new requirements. Thank you. And I'm going to turn it over to Danny Roman from Fidelis Care.
Thank you. My name is Danny Roman. I'm the Senior Manager in Network Development of Fidelis Care. This is one to just briefly go over the MCO requirements for participation. Next slide, please. So MCO requirements for participation, to participate with the MCOs, we will allow your group to provide services to eligible New Jersey Medicaid members enrolled within the plan. There's two parts of the process: provider credentialing, provider contracting. Next slide. On the provider credentialing, the way in which the MCO can verify the provider has all the required documentation to participate. It ensures quality, compliance, and accountability. Next slide. Credentialing requirements. It's usually a detailed application with all the necessary information on the application: professional license, proof of valid and current New Jersey licensee, professional liability insurance, so it's just evidence of your insurance coverage, current W-9 for federal tax ID and mailing address to pay the provider and his vendor, New Jersey State Medicaid ID to enroll in the 21st Century Cures Act. I see a question.
Thanks, Danny. We'll handle that, and if we can't handle it today, we'll get back to the person. So just go ahead and keep going.
No problem.
Thanks.
Okay, provider contracts. The contract makes you participate a provider with the MCO, allowing you to provide services to eligible MCO New Jersey members. So, when you reach out to the plans, they'll create a contract, send one for you to review. You'll then sign if all terms are agreed upon, return to the plan, we'll kind of execute, and then finally send you a copy of the finalized countersigned agreement. Next slide. Submission of the credentialing packet. Once the entire credentialing packet is signed and it's completed, it's submitted to the MCO. We then send it off to our internal units for the credentialing process to begin. The credentialing process takes approximately 60 to 90 days for completion. You can reach out to your MCOs, for specific timeframes around the perimeters. Next slide. And I'll hand it off to Blake Rogers.
Great, thank you, Danny. Hi, my name is Blake Riders, and I am a program integrity manager within NJ Special Investigation Unit. This section will focus on Medicaid requirements and guidelines for payment relative to medical record documentation, billing, and record retention. Every record must include the member's basic information, Medicaid ID, and documentation supporting diagnosis and treatment. This includes progress notes, exams, physician orders, and treatment plans. Documentation must be complete and support build codes, while records must be dated, timed, signed with credentials, and entered properly. Failure to adhere to these documentation requirements may adversely impact the record review audit and may result in administrative actions. Next slide. Every allergy and immunology claim must include the date of service, procedure performed, units, facility information, and both billing and servicing NPIs. Missing elements can delay or deny reimbursement. Next slide. Certified medical assistants are also known as CMAs, may administer injections and perform venipuncture under physician supervision, but may not assist with allergenic testing or treatment, local anesthetics, or controlled substances. This directive is in accordance with the New Jersey State Board of Medical Examiners, regulated by New Jersey Administrative Code 1335 6.4, which defines the scope of services and medical tasks for CMAs. Providers must ensure proper delegation, supervision, and documentation. Next slide. Records must be kept at least 5 years from the date of service. If an audit or legal action begins within that time frame, retain records until the matter is fully resolved. Next slide. For Division of Child Protection and Permanency, or DCP and P enrollees, additional confidentiality rules apply. Obtain records consistent with state statutes and ensure heightened protection and restricted access. Next slide. And at this time, I'll be handing the floor over to you, Tracy. Thank you.
Good morning. How are you? My name is Tracy Livingston, and I'm the Assistant Director for Data and Fiscal with the Office of State Comptroller. And I'm going to go over a couple of slides this morning. About the Medicaid Fraud Division. The New Jersey Medicaid Program Integrity and Protection Act established the Office of the Medicaid Inspector General to detect, prevent, and investigate Medicaid fraud and abuse, recover improperly expended Medicaid funds, enforce Medicaid rules and regulations, audit cost reports and claims, and review quality of care given to Medicaid recipients. These functions, powers, and duties were later transferred to the Office of State Comptroller and are carried out by the Medicaid Fraud Division. Program Integrity Oversight. This refers to the system of monitoring and auditing New Jersey Medicaid providers to ensure that they are billing Medicaid accurately, delivering appropriate services, not engaging in fraudulent practices, abusive and wasteful practices, and properly documenting the goods and services billed. Other functions that the Medicaid Fraud Division oversees: we enforce Medicaid rules and regulations. We audit, investigate potential fraud, waste, and abuse by providers and recipients. We recover improperly expended Medicaid funds, and you can actually see the funds that we recover. We post all of the reports on our website, so you can go to our website when we recover funds from overpayment letters, from audits and investigations. You can see all of that on our website. We also coordinate program integrity oversight efforts among state agencies that provide and administer Medicaid services and programs. So we work with the MCOs, we work with the Medicaid Mafuku, which was going to later talk a little bit about that later in this presentation, and we also work with sister agencies. We also exclude and terminate providers from the Medicaid program where necessary. This is very important because one of our main goals is to get really the bad providers out of the network. By us getting the bad providers out of the network, we're able to provide a provider network for the recipients that they get good quality of care. We're able to keep the costs down because there's less fraud, waste, and abuse. Next slide, please. Why is program integrity important? Protecting Medicaid funds ensures Medicaid dollars are used effectively. For instance, did you know that in the state of New Jersey, one of the highest expenditures for taxpayers' dollars is the Medicaid program? So this is a large amount of money in the state that we make sure that this money is spent appropriately. Maintaining quality of care. This ensures providers are delivering appropriate and necessary services to the patients. This is something else that our office is really big on, making sure that we're monitoring that as well. In a lot of cases, Medicaid recipients are receiving services, but we want to make sure that the services that they're receiving, there's just quality there with those services. Next slide, please. Consequences. Non-compliance with Medicaid rules, standards, and regulations regarding services may constitute acts of fraud, waste, or abuse of Medicaid funds. And again, as I stated earlier, one of the main functions of our office is to look for fraud, waste, and abuse. This is our mission for our office. We know when we do this, we're able to get the bad actors out of the program, and we're also able to make sure that the recipients are receiving the best care possible under the program. Next slide, please. I'm now going to turn over the presentation to my colleague, Kia O'Neill. Thank you.
Good morning. My name is Kia O'Neill, and I am the Assistant Division Director over Investigations in the Office of the State Comptroller Medicaid Fraud Division. I will be covering Medicaid Fraud Division actions and eligible providers, self-disclosures, and third-party liability. MFD recovery actions. This slide contains 4 types of actions that MFD may take to recoup improperly paid funds once an overpayment is identified as a result of an audit or investigation. MFD will send a notice of estimated overpayment and may also send a notice of intent and a notice of claim. MFD may add penalties, including false claim penalties per claim. MFD may also seek to withhold future Medicaid payments until the overpayment is satisfied, and may file a certificate of debt on real estate property owned by a provider or an owner of a business. Next slide, please. Ineligible providers. An ineligible provider is a person or an organization that has been debarred, disqualified, suspended, or excluded from participation in federal or state-funded healthcare programs, including but not limited to Medicare or Medicaid. Any products or services that an ineligible provider furnishes, orders, directs, manages, or prescribes in whole or in part are not eligible for payment under those programs. It is important to remember that this payment prohibition extends to anyone who employs or contracts with the ineligible provider, as well as to any facility where the ineligible provider delivers services that might otherwise be reimbursable. Providers are required to perform ineligible provider checks upon hire and monthly thereafter. All of this information can be found in the NJ FamilyCare newsletter, volume 33, number 2. Per the newsletter, providers are required to verify that any current or prospective employees, regular or temporary, contractors or subcontractors, are not excluded, unlicensed, or uncertified by searching these databases on a monthly basis. The links on this slide will help you determine whether the individuals you employ or contract with are ineligible. Next slide. Self-disclosures. The mission of the New Jersey Office of State Comptroller Medicaid Fraud Division is to mitigate fraud, waste, and abuse in the Medicaid program, resulting in cost effectiveness to New Jersey's taxpayers. As part of our multidisciplinary approach to attaining these goals, we support providers who find problems within their own organizations, reveal those issues to MFD, and return the inappropriate payments. Providers who find problems within their own organizations must reveal those issues to MFD and return improper payments. The Affordable Care Act and the New Jersey Administrative Code require that any overpayments from Medicaid and/or Medicare must be returned within 60 days of identifying that they have been improperly received. Providers who follow the protocols for a proper self-disclosure may avoid imposition of penalties. Additionally, while the specific resolution of self-disclosures depends upon the individual merits of each case, MFD may extend the following benefits to you, which may include forgiveness or reduction of interest payments, extended repayment terms, and timely resolution of the overpayment. By forming a partnership with providers through this self-disclosure approach, MFD's overall efforts to eliminate fraud, waste, and abuse are enhanced, while simultaneously offering you, the provider, a mechanism or method to reduce your legal and financial exposure. The links on this page provide information on when and how to self-disclose Medicaid fraud, waste, and abuse. OSC recently revised this information on our website, so I would encourage you to review the website. You'll also find the link to MFD's self-disclosure form, which has also been updated. Next slide. The self-disclosure process is not intended to fundamentally alter an organization's day-to-day business for handling minor or insignificant matters. Consequently, the repayment of simple, more routine occurrences of overpayment should continue through typical methods of resolution, which may include voiding or adjusting amounts of claims. It's important to understand that a provider may not extend the time to resubmit claims to Medicaid through the self-disclosure. Therefore, any overpayment must not include a reduction or netting for any underpayments discovered in the review. So what happens once you determine that a self-disclosure is warranted? Once a provider determines disclosure is warranted, an initial report should be prepared, which includes gathering the following information: the basis for the initial self-disclosure, including how it was discovered, the approximate time period covered, and an assessment of the potential financial impact, the federal and/or state laws and/or rules potentially implicated, any corrective action taken to address the problem leading to the disclosure, the date the correction occurred, and the process for monitoring the issue to prevent reoccurrence, and the name and telephone numbers of the individual making the report on behalf of the provider. The individual may be a senior official within the organization or an outside consultant or counsel, and should be in an appropriate position to speak for the organization. During this process, you must also include an Excel file containing a detailed list of claims paid that comprise the overpayments. A claims data template form is provided on the OSC website and contains all required data fields. And lastly, you must include the signed certification statement for self-disclosure, which is the attestation of accuracy and completeness, and it is also found on the OSC website. Next slide. If a provider determines that it is appropriate to sample and extrapolate as part of a self-disclosure, it should do so in a manner that is just statistically supportable. Given the complexity of statistical sampling, all work should be performed by a qualified person. The provider should include the name, educational backgrounds, and related work experience of the person performing the sampling and extrapolation when submitting the self-disclosure to MFD. MFD does not require providers to use any specific sampling or extrapolation method, but providers must provide an Excel template that contains the minimum information provided below. That includes the sampling plan, the universe sampling frame, the sample with results of the sample review, the random numbers used to generate the sample, the extrapolation methodology and output, and an explanation or description of all software used to perform the sample and extrapolation. For all of the requirements, please review the OSC website. Next slide, please. Here are some sampling and extrapolation resources if needed. Next slide, please. Third-party liability. Third-party liability exists when any entity or party is or may be liable to pay all or part of the cost of medical assistance payable to the Medicaid program. For example, Medicare, commercial health insurance, and TRICARE. Why is TPL important? The federal and the state laws, which mandate that third-party insurance must pay claims before Medicaid, ensure that Medicaid is the payer of last resort and is not making payments when there may be other insurance coverage in place that should be paying such claims. All TPL, if available, must be used first and to the fullest extent to pay claims before Medicaid, New Jersey FamilyCare pays for the care of the Medicaid recipient. It is a violation of the Federal Social Security Act to refuse to furnish covered services to any Medicaid beneficiary because of a third party's potential liability to pay for services. If you have any questions or concerns about TPL, you can contact the TPL hotline at the number on this slide. Now I will turn the presentation over to Jessica Busey from United Healthcare. Thank you.
Good morning. My name is Jessica Bussey, and I'm a senior investigator at United Healthcare. And today I will take some time to explain what we mean by fraud, waste, and abuse, which is often referred to as FWA. Next slide. Starting with fraud. Fraud is an intentional act of deception or misrepresentation. Under the statute identified on the slide, fraud occurs when someone knowingly provides false information or misrepresents facts to receive an unauthorized benefit. This may look like billing for services that were never provided or deliberately altering documentation for the purpose of increased payment. Next is waste. Waste is not usually criminal, however, it does involve the misuse of resources, which can result in recovery of an overpayment, debarment from the Medicaid program, and penalties, even if there was no intent to deceive. Waste often stems from poor practices or lack of oversight. Finally, we have abuse. Abuse falls between fraud and waste and occurs when the provider's practices do not align with proper or sound business, fiscal, or professional or service delivery practices. These practices can lead to unnecessary costs to or improper payments by Medicaid, such as reimbursement for services that are not necessary, not approved, are not documented, or fall outside of what is authorized. Understanding these distinctions helps identify risk, guide corrective action, and ensure compliance while protecting program integrity. Next slide, please. This slide provides a few examples of what could be considered fraud versus waste versus abuse. Fraud may include billing for services not rendered, billing for services while the member is inpatient, or including transportation time as time spent on site. Waste may include overutilization, misuse of resources, overuse of supplies, or billing for services that are not medically necessary. An example of abuse may include billing for services that exceed amounts that were approved by a prior authorization. Fraud, waste, and abuse generally stem from the overutilization or misuse of resources. Even if there isn't a deliberate deception, these actions can still cause significant financial and compliance risks for both providers and the Medicaid program. One area where issues may arise is providing services without proper authorization, unless the situation truly qualifies as emergent care. When providers bypass required approvals, even unintentionally, the result can be inappropriate billing and improper payments. Another risk involves using staff who are unlicensed, unqualified, or insufficiently trained. When someone performs services outside their scope or without the proper credentials, those services may not be billable, and more importantly, they can compromise patient safety. We also see concerns around inaccurate or incomplete documentation. If the medical record does not fully support what was billed, whether due to missing signatures, incomplete notes, or lack of clinical justification, then the claim becomes unsubstantiated. It is important to consider that if it isn't documented, it didn't happen. Closely related is billing for undocumented or unsubstantiated services. This includes situations where the provider may have performed the service, but the documentation isn't there to prove it. Even without intent, these scenarios can be classified as waste or abuse, and repeated patterns may be viewed as fraudulent. Lastly, many organizations run into trouble because of insufficient internal checks and balances. Insufficient oversight, like not conducting regular audits, not monitoring staff compliance, or not validating claims before submission, creates an environment where errors go unnoticed and inappropriate billing continues unchecked. Next slide, please. When we talk about fraud, waste, and abuse in Medicaid, it's important to understand how serious the consequences may be. First, there can be civil judgments and liens, as well as cases where individuals or entities can be excluded from participating in Medicaid or Medicare programs. There is also the possibility of referral for criminal prosecution. When behavior crosses the line into intentional misconduct or deception, it may be handled as a criminal matter. Providers may also be required to pay any overpayments, a process known as restitution or recovery. These amounts can be substantial, especially if improper billing occurred over long periods of time. And finally, there may be additional penalties beyond repayment, including fines and sanctions. As you can see, the consequences of Medicaid fraud, waste, and abuse are significant, legally, financially, and professionally. Staying vigilant, documenting accurately, and following established guidelines helps protect providers, organizations, and the integrity of the Medicaid program. Thank you, and I will now turn it over to Stacy Houston for red flags and case examples.
Hello, my name is Stacy Houston. I'm a clinical provider auditor lead for Anthem Blue Cross and Blue Shield, also known as WellPoint. And I'm going to go over some red flags and documentation examples that we see here at Anthem. I'll then pass things over to Jessica to complete this section of the presentation. Next slide. The first area I'm going to start in is for allergy prep. Some common red flags can include missing a mixing log, signatures, or too many units being billed. Please be aware that the allowable units will vary across payers. The following slides will show examples that both support and do not support the claim documentation. Next slide, please. The first example is documentation that supports the billing of the allergy prep. The HCFA shows the provider is billing for 20 units of antigen that has been mixed on 11/29/24. Listed is some of the documentation we received, including the prescription and the mixing log. Next slide. This is a snapshot of the prescription. It is signed by the referring provider. The date is prior to the date of service billed. We also have the mixing information for each file. Next slide. The provider also sent in a standing order noting the different phases of treatment from the buildup to the maintenance. Next slide. This is an example of a mixing log. Note that the date the serum was mixed, which is found on the bottom right hand of the document, is the same date as our claim. Each vial shows 10 milliliters were mixed, giving us a total of 20 milliliters between the two vials. 20 milliliters equals 20 units, which is what the provider is billing. This supports the code. Next slide. This is an example of documentation that does not support the billing for allergy prep services. The HCFA on this slide shows 10 units being billed. Received documentation included a mixing log and provider's notes. Please note modifier 76 is listed on the HCFA. This is for repeat procedure or service by the same physician or other qualified healthcare professional. This did not affect the reimbursement on the claim. We had no other claim for this service by the billing provider or any other provider that would support the use of this modifier. For something like this, we would educate the provider that the modifier is not appropriate as there is no other claim for this data service. If we continue to see the modifier being used inappropriately, it may be cause for a new denial. Next slide. Multiple prescription forms were received from this provider. Not all were for our date of service. Looking at this mixing form, we have a total of 5 milliliters of serum being mixed. 5 milliliters equals 5 units. Because the units on the mixing log do not match the billed units, this documentation does not support the claim. Next slide. Moving on to percutaneous tests, also known as scratch, puncture, or prick tests. These red flags are very similar to the allergy prep, including missing an order or billing the incorrect number of units. Next slide. This is an example of documentation that does support the testing. The HCFA shows 78 units for the billed date of service of 11/4/24. We received a provider note and the testing sheet for this date of service. Please note that the modifier 59, which is distinct procedural service, that is billed on this claim, was added by the provider due to a separate service that was billed on the same day on a separate claim. Next slide. This is part of the provider's note. The date matches our billed date of service. It documents the reason for the visit. It has the interpretation of the testing. It's signed by the provider. The next slide will have the testing sheet example for you to look at. Next slide. The provider note from the last slide supported the intent to order the skin testing. We have the report or log of all the allergens that were tested, and we have the provider interpretation of the test. To fully support the code, we need both the report and the interpretation. The units are found in the orange box in the center. The total number listed is 80, but the provider only billed for 78. The provider didn't bill for the controls used in the testing. Some areas, states or policies require you to subtract controls from the total number of tests billed. Next slide. This is an example of documentation that does not support the code build. We have 70 units on our HCFA for date of service 1/17/25. Documentation we received was a provider note for the date of service billed. Please note that the modifier that is billed on this claim was added by the provider due to a separate service that was billed on the same day on a separate claim. Next slide. Here we have, excuse me, a copy of part of the provider note. The documentation that does not support the code build are the report is missing. We're missing the allergens that were tested. We're missing the reaction of that testing. We don't have the interpretation from the provider. At the top of the note, it says patient presents for allergy testing, part 3, that consists of 70 skin pricks. Note only reflects 70 skin pricks and waited in the office without adverse reactions. This is not an interpretation of an actual test. We do have the signature of the billing provider, but only the printed name at the bottom with the date. Per CMS, a valid electronic signature should also have a timestamp. This claim would not be approved. It's missing a report that lists out the allergens tested, the provider interpretation of the tests, and missing a provider signature on the note. Next slide. The next red flag area we'll talk about is the misuse of modifier 25. Providers are responsible for knowing what codes have an EM bundle. The NCCI guidelines are an excellent way to find out which codes need to have that modifier. Notes need to be very clear about what is separate and distinct in order for both services to be billed. Next slide. The final red flag area I'm going to talk about is allergy injections. These red flags are very similar to the allergy prep and the skin testing, including missing order for the date of service, missing signatures, incorrect units, or billing an E&M service on the same date as the actual injection. Next slide. Now I'm going to pass the rest of the section off to Jessica to finish us off.
Thank you. This example involves billing an E&M service on the same date as allergy immunotherapy, which is typically not permitted. When a patient presents for an injection, the injection itself will only take a few minutes, and the patient may wait about 20 minutes at the office to ensure no reaction before leaving that appointment. This scenario does not qualify as an E&M visit. An E&M service may only be billed if there is a significant and separately identifiable service that is performed on the same day. The E&M service would be appended with modifier 25 and should be sufficiently documented in the medical record. In the case example shown, this provider had previously received education on unbundling. The unbundling would be when an E&M is submitted with an allergen immunotherapy code for the same patient on the same date of service, unless the documentation supported a separately identifiable E&M service that was unrelated to the injection service. Post-education monitoring was completed and showed that the provider failed to correct their inappropriate billing behavior. A review of 78 claims that billed CPT code 99213 or 99214 was conducted. 74 of the claims were unsupported due to unbundling, as the record showed that patients were seen for allergy injection procedures only. No new issues or complaints were addressed during the visit. Next slide. In this example, an investigation was initiated based on data analytics that were designed to identify outliers and unusual billing activities and patterns. For AIT serum preparation, CMS placed a medically unlikely edit at 30 units a day for AIT serum preparation, and it was suspected that providers may try to circumvent this by billing 30 units over multiple days within a month. Next slide. Our data analytics identified providers who prepared 46 plus injections over a 30-day rolling window. In one case example, a provider was identified where 29% of their billing of CPT code 95165 exceeded this threshold. There were instances identified ranging from 50 units to up to 240 units of serum prepared for a member in a 30-day rolling window. Review of medical records and discussions with the provider supported that all units of the extract for an individual were created at the same time. However, the provider intentionally and inappropriately billed CPT code 95165 in 30-unit increments over multiple days to avoid the MUE. The provider was educated that there may be situations where a professional reports units accurately and those units exceed the established MUE. In all situations, the provider should be accurately billing all units of extract on the date that they were created. Next slide. Ultimately, MCO policies may change over time, and it is recommended that the payer be consulted to obtain correct billing information. Thank you, and I will now turn the presentation over to Sergeant Michael Rosati.
Yes, thank you. Good morning, everyone. So I am Sergeant Michael Rosati with the state's Medicaid Fraud Control Unit. Medicaid fraud is a serious crime, and as detailed throughout this investigation, there are instances in which the acts of a provider or organization violate state law. Our office, the Medicaid Fraud Control Unit, is within the Office of the Insurance Fraud Prosecutor, and we are the criminal oversight entity for our state. Our office investigates and prosecutes a wide range of cases that include traditional Medicaid fraud. We conduct these investigations through both civil investigators, criminal investigators, which are sworn law enforcement officers. We also have nurse investigators, auditors, analysts, and other support staff that help us to police the Medicaid system. So we investigate and prosecute alleged criminal actions, which include allegations of physical abuse to beneficiaries, fraudulent activities by providers against the Medicaid program, fraud within the administration of the program, and fraud against other federally or state-funded healthcare programs where there is a Medicaid connection or nexus to Medicaid. Our cases largely come from referrals, and those referrals can be either from patients, other members of the public, other cooperators, cooperating defendants, cooperating witnesses, and we do also get a substantial amount of referrals from our partnered agencies, which include the Medicaid Fraud Division, as well as the MCOs or managed care organizations within Medicaid. Next slide. So there's quite a few criminal statutes that we use to apply to our cases. One of the most common ones in fraud cases is highlighted above. So that would be criminal healthcare claims fraud. So under that statute, it is illegal to submit a false claim to the Medicaid program or an insurance company in order to be paid for healthcare services which were not received or provided. This is a second-degree offense, which means it is punishable by up to 10 years in state prison. In addition to all other criminal penalties allowed by law, a violator of this statute may be subject to a fine of up to 5 times the amount of any false claims. In addition to this, there's also a suspension or debarment from government-funded healthcare programs, and it may result in forfeiture of a professional license. Next slide. So just some things to keep in mind relating to the submission of false claims. If you are a practitioner and you hold a professional license, you only need to submit one false claim to be convicted under the statute. Willful ignorance of the truth or falsity of a claim is not a defense, and you can be found guilty of healthcare claims fraud even if your claims were not intentionally fraudulent. And just to bear in mind too, there's also a number of related criminal offenses that often go hand in hand, such as theft by deception, and then there are also specific Medicaid fraud statutes. Next slide. So to keep it very simple, the bottom line is ignorance of the law excuses no one, and it's the provider's responsibility to know the laws that apply to their area of practice. And with that, I will turn it back over to Melanie. Thank you.
Terrific. Thank you. So we have ended a bit early today. We've reached the end of our presentation, but we want to make sure that we leave you with some resources that are going to be helpful for you. So the following slides contain contact information for the relevant state agencies and managed care organizations. Please don't hesitate to use this information and reach out if you have questions or you need to report something. We want to make sure that we hear from you, and we are here if you do have questions. If you have a question after you leave today's presentation, I want you to jot down this email address. This email address routes directly to me, and I have access to triage questions to the right agency or managed care organization if you have something that's related to today's presentation. So certainly please use this if you think of something after you leave today. We do want to know if you found today's presentation helpful. So I do want to launch a very quick feedback poll. If you could answer 3 very short questions and let us know what your thoughts were with today's presentation, we would greatly appreciate it. And with that, we just want to thank you again for joining us today. We hope that you took away something, that you learned something new, and we hope that you enjoy the rest of the day. So thank you very much. And for those of you that asked questions, we will be following up and be responding to you with that information. So thanks again, and enjoy the rest of your day.